and welcome back to SEC Roundup. I'm Nick Morgan, partner at Paul Hastings and the chair of the Investor Choice Advocates Network and the co-host of today's episode, where we are joined by an amazing cast of luminaries. I don't want to overstate things here, but I'm really pleased that you all could join us for this. So what we're going to do here today is, as the SEC does every year, they recently announced the enforcement results for fiscal year 2023. And so we've gathered you all together to get your thoughts on some of the specifics of those results. And hopefully we get some takeaways that we can learn from for going forward in 2024. So we are first pleased to be joined by Kit Addleman from Haynes & Boone, former regional director at the SEC. Kit, thank you for joining us.
Thank you for having me.
Also, Sandra Hanna, who's a member at Miller & Chevalier. Sandra, thank you for joining.
See you.
My partner, Ken Herzinger, in the San Francisco office of Paul Hastings, who is the chair of the Investigations and White Collar Defense Group at the firm and formerly from the SEC in San Francisco. Ken, thank you for joining.
Yeah, great to be here.
Mark Schonfeld, Gibson Dunn in New York, and the former director of the New York Regional Office. Mark, welcome.
Thank you very much. Glad to be here.
And finally, but not least, Tom Zaccaro from Houston Hennigan in Los Angeles and the former regional trial counsel in Los Angeles office. Tom, thank you for joining.
Thank you, Nick. Nice to be here.
As always, and you'd normally be co-hosting, but now I'm going to impose on you as a guest. So thanks for joining. So as I said, the SEC's annual enforcement results came out. A couple of interesting, just top level issues. The SEC did bring a lot of cases last year. There were 501 standalone cases, 784 total actions, which was up from the previous year. But interestingly, if we're trying to compare current share to past share, the Gary Gensler 2023 results were down a bit from the Jay Clayton 2019 results. In that year, 526 standalone actions were brought and a total of 862 actions in 2019. So slightly down from 2019. These numbers don't vary a lot from year to year, so those numbers are not too much of a surprise. The dollar amounts that were ordered to be collected in monetary relief, $4.9 billion. And for those of us who've been doing this a while, that seems like a very large number, and it is a very large number. It breaks down at $3.4 billion in disgorgement, $1.5 billion in penalties. But that was down 23% from last year, where last year we saw, meaning fiscal year 2022, we saw some really eye-popping civil penalties imposed in that year. So again, these numbers don't change a whole lot from year to year, but those are the numbers that came out from the Enforcement Division for fiscal year 2023. Let's get into some of the specifics. Again, the case makeup doesn't change a whole lot, but I think there are some lessons we can learn from the types of cases that were brought. Kit, let's start with you. If we could talk a little bit about the cases brought in the investment advisor and private fund space, that would be very helpful. Thank you.
Yeah, happy to talk about those. And since you started with numbers, I will turn to numbers first as well, which is that the investment advisor private fund area continues to be one in which the SEC spends a lot of energy and a lot of resources. Roughly 17% of the total actions that the SEC brought in the enforcement program were in that space. 24 in district court, 62 in terms of original APs, not the follow-on to injunctions or convictions. I thought I'd highlight a couple of those areas that the SEC has focused on most prominently. One that was a little bit of a surprise to a lot of us was how quickly they jumped on violations of the new marketing rule, which prohibits, among other things, the use of hypothetical performance in advertising, unless there are specific policies and procedures to make sure that it's addressed to the right people and current clients who can appropriately understand hypothetical performance numbers. It started with a big case against the fintech firm Titan Global Capital Management. That case involved more than just the marketing rule, though. It also included allegations of other compliance failures leading to misleading disclosures, as well as, and I think this is important for advisors and funds, hedge clauses which purported to limit liability. That matter was followed by 9 additional cases in a sweep in September, just right before the close of the year, with penalties totaling $850,000 cumulatively. There was a similar case against Wellesley Asset Management in September regarding the use of hypotheticals, but also largely around the use of an index in advertisements for comparative purposes that the SEC alleged didn't disclose the methodology and was therefore potentially misleading. The second area I wanted to talk about with respect to investment advisors and funds is related to misleading or missing fee disclosures that the SEC alleged. There was a big case, a lot of press around Merrill Lynch action that involved the failure to disclose certain foreign exchange fees in addition to other markups or markdowns that had been disclosed. There are a number of cases that were brought last year involving calculating the fees inconsistently with client arrangements, largely around what appeared to be procedural failures that led to the improper fees being charged. Another big name in this category included Wells Fargo, where the allegation in the commission's order is that there was a simple failure to input reduced fee arrangements that had been reached with clients into the computer systems. Fees paid to affiliates. This is sort of in the bucket of both fees and conflicts of interest, which I'll get to in a minute. But the issue of fees paid to affiliates and disclosures about that is a big part of enforcement, as well as what we saw in the exam program last year. So for example, in the real estate area, fees paid to a real estate firm for brokerage commissions in real estate acquisitions was a part of an action that was brought. And as I mentioned, then the third area I wanted to highlight was conflicts of interest. Unusual area this year that we saw in 2 different cases involved SPAC conflicts, specifically where the investment advisors personnel had an ownership interest in a sponsor entity to the SPAC. There were also continuing actions that we saw involving revenue share arrangements for compensation to the investment advisors, like the 12B1 fee cases that we saw in the past, custodial fees for cash sweep accounts, and others. One of those, in fact, was the Commonwealth Financial matter, which was litigated and involved a finding by the district court of misleading disclosures with respect to the compensation that the advisor was receiving. I actually got a big kick out of another conflict case involving the co-portfolio manager to a BlackRock fund, where the fund made an investment in a film-related company, and the portfolio manager purportedly used that relationship to get a film role for his actress daughter. So any number of things that can be deemed to be a conflict of interest. I think there's a grab bag of other issues in the investment advisor and fund area that I would include as a highlight from the 2023 results, including cherry picking, specifically one action that alleged the late day allocation of trades to a specific individual and family members was a problem. And of course, we've seen that allocation issue for block trades come up a lot in exams for both investment advisors and private funds. Several cases involving insufficient policies and procedures and late filings of Form CRS. And then allegations of cash solicitation rule violations in the context of the retention of social media influencers. So I think what we'll continue to see in terms of takeaways from 2023, continuing into 2024, is going to be the continued emphasis on the marketing rule, always present fee disclosure and conflicts of interest, custody rule for private funds, off-channel communications, and trade allocations. Thanks, Nick.
That's a lot to keep track of. And it sounds like it's a mix of things we've seen every year recurring, cherry picking and the like, and some new issues that are cropping up. So plenty for investment advisors and private fund advisors to keep track of. I think it's interesting that the report, which is generally meant to be kind of a cheerleading exercise, doesn't talk about significant losses. And of course, there was the Cap Wealth jury trial loss in Tennessee last year, and doesn't come up in the report. But it would be interesting if the SEC did some soul searching about why that was a 12B1 case. So why do they lose cases like that? So, but perhaps next year's report will have some of that.
Yeah, always a press release for a successful court action, never the press release on a loss.
Right.
Or Ripple. There was no press release went on the Ripple litigation, which was not insignificant.
Didn't see that gone into in any great detail in this report. So Sandra, what about auditors? They're a perennial focus of enforcement. They of course have the PCAOB out there as well. So what happened with the SEC and auditors this year?
I'm going to talk about gatekeepers sort of generally, and auditors are most of those cases per usual. I think we're always going to see a focus on gatekeepers. I check to see how many speeches there have been in the last 2 years that say the word gatekeepers, and it's like almost too much to count. And on the auditor front, there's some new things there, and there's a level of aggression on the auditor cases that we've not seen before, I think, including, I think there were 21 standalone cases against CPAs this year. So not all auditors, just CPAs generally, and some interesting observations on those. There were several contested ALJ proceedings brought against auditors, including in this fiscal year, including while Jarchese was winding its way up. And I think oral argument is tomorrow in that case, so that'll be good to watch. A few of these cases were stayed because of Jarchese ultimately, but only pretty recently. The fact that the staff brought them as 102Es as contested ALJ proceedings is pretty remarkable. They could have charged them in federal court, but didn't. One of them is Abraham's, which relates to the Mattel restatement, which was a settled matter that I think we may talk about later. And there's another case called Markowitz that was also brought as a contested ALJ proceeding really in the middle of the fiscal year, that's also now been stayed. And that one is unusual only because the facts aren't that interesting, but it involves pretty old conduct going back to 2014. The big auditor actions this year were the $10 million case against Markham and a parallel proceeding brought by the PCAOB on the same day. I think it's the first time we've seen parallel proceedings, or that I can remember parallel proceedings, but we've been promised to see more of them, that we'll see more of them in the future. And the Markham proceeding is interesting because the remedy was kind of crazy. They alleged a wholesale failure in Markham's quality control system. It's kind of an old story about a small company growing too big too fast and not having internal controls to manage that growth. So in the course of a year, they took on something like more than 600 new audit clients, assurance clients that were largely all SPACs or de-SPACs. And there were wholesale failures the staff alleged there. And one of the things that they had to take on was an independent compliance consultant and an undertaking that there would be no more than 3 new clients per quarter. And everything had to be approved by the ICC. And it's pretty extreme remedy for an audit firm to take on. On the last day of the fiscal year, they brought an interesting case, contested civil proceeding against a firm called Prager Metis. That is an independence case. It'll be a good one to litigate. Really good defense counsel on that matter. And the allegation there is that the firm had hundreds of independence-related violations because they had an indemnification provision in their engagement letters. The staff isn't alleging that they were actually ever improperly indemnified, but the indemnification provision in the hundreds of engagement letters over the course of many years alone is the independence violation. They also charged it as aiding and abetting, both primary and secondary aiding and abetting charges there. It's a really strange case. I can only, I don't know, but I can only guess that it didn't settle because the numbers the staff were seeking were just, way too high. It's a pretty unusual allegation for another reason, because the indemnification provision actually isn't outlawed by the rule. The rule doesn't say anything about indemnification. There are some FAQs on independence that mention indemnification, but it's not in the rule. So I think the staff may face some challenges as it goes to litigate that. Elsewhere in the gatekeeper world, there are two cases worth mentioning. One is a case against a fund administrator, TFS, where the staff alleged that in calculating a NAV, the fund administrator sort of took the asset manager's assertion that something was an expense at face value without doing more. It's really rare to charge a fund administrator here. I think the last case was something like 2015. So that's unusual. The other unusual case is against the CFO of a company called View. That was a window manufacturer. That's an accounting case. We can debate over a glass of wine sometime whether or not a CFO is actually a gatekeeper, but the staff has long taken the view that the CFO is a gatekeeper. This is unusual because it's a rare instance of the SEC litigating a standalone negligence-based charge, which I can't recall ever happening. So I can only imagine the penalty the staff was seeking in this case must have been impossible for the CFO to swallow. And so this one too, I have an alert set for. We'll be watching it really closely. I think that's it on the remarkable gatekeeper things. I do want to say that the parallel action with the PCAOB and the SEC on the Markham case is kind of game changing for the audit firms and for audit professionals. And so we should all keep a close eye on that, especially as the PCAOB is itself coming up with fines that are unprecedented in its history, certainly.
Yeah, the independence and indemnification issue, depending on how far they try to take that concept, that could fundamentally change the relationship between auditors and audit clients. That's a big deal.
Yeah, and perhaps I would understand the case if they had actually been indemnified for something, but it's just a term in an engagement letter.
Wow.
And pretty aggressive.
Yeah. Well, so your focus on gatekeepers is a nice segue. Can individuals are always a focus of SEC enforcement actions, maybe this year more so. What kinds of remedies are being imposed against individuals in the last fiscal year that we might want to take note of?
Yeah, thanks, Nick, and I agree. Sort of segues nicely with Sandra's summary of the gatekeepers. So just before jumping into the remedies, I thought, talk a little bit about the stats about cases against individuals. So similar to prior years in, fiscal 2023, the SEC reported that approximately 2/3 of the cases it brought, involved one or more individuals. So nothing really, I'd say, sort of eye-popping as compared to prior years in, whether or not they're naming individuals. Really, the key data point they cited, which is as to the remedies, is that the staff obtained 133 D&O bars and other bars against individuals, which they said is the highest number of D&O bars in a decade. And I haven't checked the stats, but it is a real significant number. And then on top of that, and I think Sandra mentioned this before, they also filed 162 follow-on administrative proceedings seeking a bar or suspending individuals, from operating before the commission. based on prior criminal convictions or other civil injunctions. So, going back in time. And, it's interesting that the staff cited 3 different cases as exemplars of, the uptick, I guess, in their efforts to seek D&O bars. One was a former bank executive who agreed to a permanent officer and director bar as part of a settlement of, alleged fraud charges. And the executive also agreed to pay $3 million in a civil penalty and $1.9 million in disgorgement and prejudgment interest. It's interesting, statistically at least, across the board, it does appear that penalties have gone up and disgorgement has gone down slightly. Not, I guess, surprising to this group, based on where the law has trended. But at least, in that action, they certainly, recouped a significant disgorgement amount. The other matter that they highlighted was a former CEO of a public company who agreed to a 5-year officer director bar. Again, alleged fraud charges in connection with circumstances surrounding his termination from the company. And he agreed to pay a $400 million civil penalty in that matter. No disgorgement, but a pretty significant civil penalty. And then the last one that they highlighted was a telecommunications company's former controller. And this kind of dovetails with, the auditor piece that Sandra was hitting on. So the controller agreed to a permanent officer director bar and a 102E accountant bar as part of the settlement. And there were alleged fraud, revenue recognition issues involved. So, I'd say unusual facts as it relates to a controller. But, all of these cases and the stats definitely underscore what I think a lot of us have been seeing real time behind the scenes, which is that the staff is becoming much more aggressive on officer director bars and 102E bars in the midst of negotiation, and is in more cases than at least I've experienced seeking permanent bars right off the bat. And that to me is a bit of a change in their normal approach to individual bars, and is definitely an increased effort, I think, to send a signal to individuals, which is what they said in the press release. Coming on the heels of Enforcement Director Greenwald's speech at the New York City Bar, which I'm sure you guys saw back in October, sort of giving a shot across the bow to chief compliance officers, some of the cases Sandra mentioned, and then those of us following the Solar Winds case with the recent charge against the CISO, which is first of its kind. I think our clients and individual clients in particular are definitely hearing the message the staff is sending, and it'll be interesting to see how this all plays out in litigation, because if the staff indeed is intent on seeking permanent bars, then I think we're going to see a lot more of these cases go to litigation, because that's obviously a pretty significant penalty for individuals operating in the industry.
Yeah, absolutely. I think your prediction of more litigation is correct. Sandra mentioned the Jarkissi case. Tom's going to talk about that in a minute. If at the same time the staff is getting more aggressive with individuals with potentially career-ending remedies, and courts are limiting the tools that are available to seek those types of remedies, I think that can only lead to exactly what you said, Ken, which is more litigation. Well, stay tuned for that. But a lot of the individuals talking about are officers and directors of publicly traded companies. So and obviously this area of the SEC's enforcement program is hugely important. Mark, can you give us an overview and maybe some highlights from the enforcement program as it relates to public companies and financial reporting issues?
Yes. I want to focus on sort of 2 aspects of this component of the SEC's enforcement program. First, what the SEC highlighted itself in its sort of year-end results, but also what they didn't highlight because I think sometimes what they choose not to talk about can be more interesting and instructive than what they do choose to talk about. And this will be about public company, both financial reporting and general disclosure type cases. And as in previous years, this is a traditional area of focus. And again, this year there was sort of a similar proportion of the enforcement caseload that was comprised of these public company reporting cases, about roughly 17% of enforcement actions overall, which is consistent with prior years. And, consistent with the trend of this administration, there have been substantial penalties imposed through settlements against public companies in the tens of millions of dollars. And as you point out, individual executives, often former executives by the time these cases are settled, have been named in many of these cases. What is also interesting, if you look at the cases that they chose to highlight in their year-end announcement, they cited about 6 cases for this category. 4 of them involved cases against electric vehicle companies or companies in that sector. And of those 4, 3 of them went public through mergers with SPACs. So I think it tells you a couple of things about the SEC's enforcement priorities over the last few years that lead to the cases you see this year. There's obviously been a focus on companies that went public through SPAC mergers, which mainly took place in what some of us refer to as the SPAC boom of 2020 and 2021, prior to the SEC clamping down on those types of mergers. And we're now seeing sort of the byproduct of those companies that went public this way, which, for some reason seem to be a lot of electric vehicle companies. And the other interesting thing about these cases is they tend to focus on statements or disclosures the companies made about their prospects for the future. So for many of these, the issue is not so much did the company report its actual financial results accurately, but rather the company made forward-looking projections either in connection with the merger with the SPAC or afterwards about anticipated revenue, about anticipated sales and sales growth. And when those projections have not turned out the way they were hoped for, the SEC has turned those into disclosure violations. So one thing it also highlights is the importance for those of us who are counseling companies making forward-looking statements about growth prospects, is that you carefully scrutinize the basis for those statements, because we've all seen amply that the SEC tends to look at those in hindsight. And of course, when the predictions don't happen, that is ripe for investigation. The other area that I want to focus on, which I said I thought was the more interesting part, is the SEC's focus on what we can call disclosure controls or internal controls for disclosures. And what is notable about these is the SEC bringing these cases and settling them with public companies, but also the dissent that is coming from the Republican commissioners about these settlements. It is rare, first of all, for a commissioner to dissent from a vote on an enforcement recommendation, particularly one that is settled, where the settling party has agreed to it. And at least a majority of the commissioners have agreed to accept that offer of settlement. But in a couple of recent cases, one during this past fiscal year and one since even more recently, Commissioner Peirce has been particularly vocal about her opinion her view that these internal controls cases are actually not an appropriate way to resolve what at least the staff or the other members of the commission believe to be disclosure issues for these companies. So The first of these, which was earlier in the year, was against a company called Activision Blizzard, which is, a technology company that, had said in its risk factors that employee retention and its ability to retain and recruit employees would be an important component of the company's ability to succeed on its growth mission. The SEC faulted the company for not having sufficient internal controls to make sure that information about workplace misconduct and employee complaints were getting to senior executives and disclosure decision makers so that the company could make a decision about whether there was something material to disclose. And the company paid a $35 million penalty for that resolution. Well, Commissioner Peirce was pretty vocal about her disagreement with this, because essentially what she was saying is that the SEC is taking a disclosure controls requirement, which requires that the company have controls to make sure it captures information that is required to be disclosed, into a requirement that companies have internal controls to collect, nobody knows exactly what information, so that people can make a decision about whether there is an obligation to make a disclosure. And as she pointed out, it's difficult to see where the logic of this rationale stops. And sure enough, the issue came up again in a case against a company called Charter Communications, even more recently, where the SEC faulted the company for executing corporate stock buybacks over a course of many years, utilizing 10b5-1 plans that the SEC contends did not conform to the requirements of Rule 10b5-1. Putting aside the question of whether the plans actually did or did not conform, again, this was settled as an internal controls case on the theory that the company didn't have internal controls to make sure that it carried out the buybacks in conformity with the authorization from the board. And in response to this, Commissioner Peirce issued another dissent in which she referred to the SEC's use of these internal controls provisions as its own Swiss Army knife statute. That is a multi-use tool handy for compelling companies to adopt and adhere to policies and procedures that the Commission deems good corporate practice. Well, it will be interesting to see if this trend continues. I can imagine that there are competing incentives here, because sometimes companies may be perfectly willing to enter into a settlement on these terms to avoid what might be a much longer and more drawn-out investigation, or possibly more severe contested litigation. But it will be interesting to see if companies also take more principled stands on these issues and simply say, this is not right, this is not a reasoned basis for settling an action, and the SEC ought instead just not to pursue any enforcement action whatsoever.
Sounds like more litigation, Mark.
Could be.
Potentially, yeah. Well, and if you couple what you were describing as the SEC's benefit of hindsight with this very broad conception of what internal controls are supposed to capture, it's sort of hard to advise clients on how to devise in advance, how to devise the internal controls to capture what might happen in the future. Interesting. Well, maybe we'll see some litigation, and maybe a judge will have a different view, and we'll be wiser at this time next year.
It will be interesting to see if any of these cases result in litigation of this issue, because I have a feeling that Commissioner Peirce has the better side of this argument, and I have a feeling that the Commission doesn't have an appetite to actually test this theory. Yeah. Well, we'll keep an eye on that one, and maybe such a case will come about, to make a rough segue here, as a result of a whistleblower. Tom, the SEC has taken great pride in recent years on touting its numbers in the whistleblower program.
As with other areas, the enforcement program, they tend not to focus on things like all the cases they didn't pursue, frivolous tips, meritless tips, that kind of thing. But what did the SEC say about the whistleblower program this year, and how does it compare with prior years?
Yeah, thank you, Nick. And I think it's probably appropriate we finish with whistleblowers because I think the enforcement results that everyone on this distinguished panel has already discussed have been partially fueled by the whistleblower program. The results this year, and I'll start with the statistics like we all have, but the results this year have been astounding. The SEC received in its fiscal year 2023, 18,000 whistleblower tips, a 50% increase over its prior record of 12,000 tips. So when you do the math, this turns out to be about 70 whistleblower tips per business day, which to me is shocking. If you do a little bit more math, if only 10% of these whistleblower tips warrant investigation, that's 1,800 new investigations, which arguably would not have opened absent the whistleblower tip. For those of us who were at the SEC know, it's not an easy thing necessarily to open a new investigation. These numbers are reflected in the ultimate enforcement results of the Division of Enforcement. And whistleblowers and perhaps the increase in tips can be explained by the rewards that whistleblowers receive. The rewards this year, again, highest among the highest in SEC history, the largest being a single $279 million award to one whistleblower. I mean, you can't get that except a winning lottery ticket. So, if you're in-house in a company and you learn of something that's potentially an SEC violation, of course you're going to run to the SEC if the potential for a 9-figure bounty is available to you. So the program has been, I think, enormously successful in 2023 as well. And of course, the SEC goes out of its way to protect whistleblowers. And we saw that again in 2023. It started protecting whistleblowers really in the after Dodd-Frank was passed, when the commission adopted Rule 21F17, which says essentially that a company can't do anything to impede a whistleblower. And that the SEC has enforced that rule consistently over time. The first case it brought was in 2015, actually on April Fool's Day in 2015 against KBR, because KBR had confidentiality agreements or provisions that it used in internal investigations, and it advised witnesses that anything they said during the investigation was confidential. The commission took exception with that and brought its first enforcement action. It brought a series of enforcement actions after that against employers, mostly for having confidentiality provisions in severance or separation agreements, or had other procedures which required employee confidentiality. There was a lull in those cases for 3 or 4 years, but we saw 3 of them brought in September of 23, including one against a registered investment advisor, which resulted in a $10 million penalty, by far the largest penalty in a Rule 21F17 case. And there, the investment advisor required its employees to sign agreements that said 2 things. One, don't make disclosures. You can't disclose any business or confidential information outside the company. And 2, the employees had to attest that they had not filed any any complaints from any federal agencies against the registered investment advisor. So the SEC took exception that this potentially impeded whistleblowers, and assessed a $10 million penalty. There were other cases, 2 other cases the commission brought, which again targeted separation and severance agreements, which restricted what the former employees could say to federal agencies and required those employees to attest that they would not share in any whistleblower reward. So the commission remains active in this space. It's a warning shot to employers just not to have any agreements which precludes the passing of confidential information to the SEC. That has to be a carve out in any confidentiality provision any employer uses, or they will face the wrath of the commission. And then finally, circling back to the case that Sandra mentioned earlier, Jarkessi, major case for all SEC practitioners. It's a case out of the Fifth Circuit which held that the SEC administrative proceedings are unconstitutional. The argument is before the Supreme Court tomorrow. It's a major case for SEC enforcement. You know, all of us who are on the staff, we love bringing administrative cases, and now when we're on the defense side, we hate them because the procedures vastly favor the SEC as opposed to being in federal court. All of us have been fighting the administrative state of the SEC, and Sandra's right. The SEC may see the writing on the wall because they agreed to stay all contested administrative proceedings until after Jarkessi is decided. So I will be listening intently at 10 a.m. Eastern time tomorrow during the arguments, and hopefully the Supreme Court, which has not been friendly to the SEC, will take action to reinstitute fairness in litigating proceedings between the SEC and its targets.
Well, Tom, I think that's a great place to leave it. And it sort of ties up some of the themes, I think, in each of the areas, with Kit with investment advisors, and Sandra with auditors, and Ken with individuals, and Mark with public companies and other disclosure cases. Each of those suggest a more aggressive stance. Jarkessi, his Supreme Court appearance at tomorrow's oral argument will be the culmination of a 10-year fight with the SEC. Perhaps this means there will be more litigation in each of these areas that we've talked about as the SEC continues to take more aggressive stances. Kit, Sandra, Ken, Mark, Tom, thank you so much for joining us. We will see the rest of you on our next SEC Roundup.